But without further ado, on we go with our talk on delivery, cancellation and frustration, which, as you know, is the first talk in our series of webinars on voyage charters. Just looking at the list of RSVPs to today's talk, it's great to see a few of the same names on the list that attended our Time Charters series back in the spring, and equally quite a few new names attending Birketts webinars for the first time. So you're all equally welcome and great to have you on board. Just a few housekeeping notes before we carry on. Those of you who attended the Time Charter courses will be familiar with these by now. The first of which is, please forgive any technical glitches which may arise during the webinar. This is live and that's just the nature of these things. Similarly with background noise, I think I'm right in saying that Pamela and I are in largely empty houses, although Pamela may have a few stray pets wandering around the house who may come in to say hello from time to time, so go with it please. If anyone has any questions or indeed technical queries, please can you use the question box on the right hand side of your screen, put your questions in there and we'll do our best to address as many questions as possible at the end of the talk. A copy of these slides will be circulated at the end of the talk as well, within a day or two, so you'll have the slides available for yourselves to have a look at later on. And similarly, we'll also publish recordings of these talks. So if you'd like to watch the talks again, or you have any colleagues who you think might be interested, there'll be the opportunity to do that as well. And then finally, there will be a survey, a very short survey that will come up at the end of the talk for you to just complete, if that's okay. Your feedback is really valuable to us, and we've taken into account a number of comments from the Time Charters webinars when considering how to present this latest series of webinars on voyage charters. Okay, so without further ado, please could we go to the slide that sets out the Birketts Shipping Team. Thank you. And so for those of you who are not yet familiar with our team, here we are all set out in glorious A4 Technicolor. Please take a moment just to have a look through the team. As you can see, we're a team of roughly 12, I think the last time I counted, of shipping lawyers with various specialisms and niche expertise. And there we are set out on that page. And then on to the next page, Ken. And again, those of you who attended the Time Charters course will be familiar with Pamela and me now. Good morning, Pamela.
Hello, everybody. I'm going to be dealing with the middle section of this talk on the delivery voyage of the vessel.
Great. And next slide, please. Okay, so just to set out briefly what the structure of today's talk looks like. Firstly, I'm just going to take a moment to introduce voyage charters in general terms, and we'll just have a look at the topics that we're going to deal with throughout this series of 6 talks. And then we'll get into the real meat of today's talk, which is on, as you know, delivery, cancellation and frustration. And within that talk, or within that subject, we're going to be looking in particular at issues concerning the description of the ship, issues that arise in relation to the vessel proceeding to the load port and cancellation of the charter. And then finally, at the end, we'll have a look at frustration and force majeure in a voyage charter context. So that broadly is what we're going to be talking about. First of all, to look at voyage charters in general terms, and it's useful to compare them to time charters to try to draw out some of their main characteristics. But essentially what a voyage charter is where a subcharterer hires a vessel for a voyage from A to B in return for the payment of freight to the owners, and almost everything is included in the charter party. So by contrast to a time charter where there's a daily hire rate payable and there are extras payable on top like bunkers and other costs that arise during the charter, usually a voyage charter captures all and provides a fixed cost for the payment for the ship for a voyage from A to B. Payment is usually by means of freight, which is usually payable in 1 or maybe 2 or 3 lump sums as opposed to any kind of daily rate. And you may find it helpful to go back to the black cab versus mini cab analogy, with a black cab being more like a time charter arrangement where the cost of the journey in question depends on the time that you use the black taxi, whereas a voyage charter is more like a mini cab or possibly an Uber ride where you know what the journey is going to cost all in at the beginning of the booking, and the car then just takes you from A to B. And the next slide, please. Thank you. So you should hopefully remember, those of you who attended time charters, this diagram which shows the overall contractual matrix of different charter parties, bills of lading, contracts of carriage, sale contract, and how they all fit together. So just to recap briefly, we've already looked at the time charter arrangement between the head owners and the charterers at the top of that diagram. Within that chain, there may then be a series of time charters, so there could be 2 or 3 time charters. There may be a trip time charter involved. We're not going to look at trip time charters in detail on this course, but what a trip time charter essentially is a hybrid between a time charter and a voyage charter, where you have lots of characteristics of a time charter, like payment in hire, but it's only for a single voyage from A to B. Okay, but let's put those aside for the moment, because that could confuse things. And what we're looking at in this series of talks is the voyage charter scenario at the bottom there, between a sub-charterer who will in fact be the disponent owner under the voyage charter, and then a sub-charterer. And often the sub-charterer under a voyage charter will be one of the parties with an interest in the cargo. So here's the series of 6 talks that we're going to be delivering over the next couple of months or so. As you know, today, delivery, cancellation and frustration. And then we're going to have a talk on ports and berths and deal in particular with safe port and safe berth issues. That's in a couple of weeks on a Wednesday. Then we are going to, Sarah and Alex Smith are going to look at cargo operations and stevedores. And then we've had lots of questions and expressions of interest in laytime and demurrage. So we're going to dedicate 2 separate talks to laytime and demurrage in the middle of November and the beginning of December. And then finally, we'll wrap things up approaching Christmas with a talk on bills of lading, freight liens, and clauses paramount, which introduce Hague and Hague-Visby rules into voyage charters. Okay, and we've reduced this series of talk to 6 from 8 talks that we did for time charters, because we feel like that perhaps is a bit more of a balanced and manageable number for people to go with. Okay, so moving on to the substance of today's talk, I think our technical issues are over. We're in a good place, so let's crack on. And the first thing that we are going to talk about is the descriptive statements that appear in voyage charters relating to the vessel. Okay, now obviously if you're a charterer and you're hiring a ship to carry a cargo from A to B, it's really important to you that the ship in question is suitable for the carriage of the particular cargo. And it's also really important that the ship turns up on time and is physically capable of carrying the cargo in question. And as a consequence of that, the descriptive statements that appear in the voyage charter that describe the ship are very important, and it's been held that they indeed amount to contractual terms and not just mere representations. Now, as you'll know, the effect of this is that the breach of a contractual term will give rise to a contractual remedy for the innocent party. And the nature of that remedy will depend on the classification of the term in question. This goes back to the question of warranty, condition, or intermediate term that we discussed on the time charters course. And just to recap very quickly, in case it helps, a warranty under English law is a term in a contract that doesn't generally go to the root of the contract or isn't a particularly key term in the contract. The breach of that clause, in that particular type of clause, will sound in damages only. So the innocent party will have a damages claim. A condition at the other end of the scale is a clause that goes to the root of the contract. It's a really key term in the contract. And if a party breaches a condition, then the innocent party will firstly have a right to damages, but will also have a right to terminate the charter. Okay, and then the third type of term, as you'll recall, is an intermediate term or an innominate term. And this sits somewhere in between the condition and the warranty, and the nature of the remedy available to an innocent party in the event of breach will depend on the nature and the gravity of the breach. Okay, a relatively minor breach will probably sound only in damages, whereas a more serious breach may also give rise to a right to terminate the contract. And you'll remember that that intermediate terms were dealt with, in fact, in a number of cases, but the Hong Kong Fur is a well-known time charter case that dealt with intermediate terms. So if you want to have a look in that in more detail, the Hong Kong Fur is a good place to start. And again, during this series of talks, we'll be looking at warranties and particularly conditions and intermediate terms quite regularly. So it's good to get your head around the distinction between those 3 different terms if you haven't already. And then the final thing to say in relation to descriptive statements in the voyage charter is that the failure to deliver a vessel that meets those statements may also amount to a misrepresentation. Okay, and remedies for misrep are slightly different to remedies for contractual breach, but you'll often see in claims of this type that a claim for misrep will sit alongside a claim for contractual breach. That's all we're going to say about misrepresentation in today's talk, because it's beyond the scope of the talk, but just something to be aware of, that you may well come across this when handling these types of issues. Okay, so we've dealt with the fact that, in principle, descriptive statements in voyage charters will amount to contractual terms, breach of which gives rise to a remedy. Now let's have a look at some of the types of descriptive statements that you might come across in voyage charters, and consider how they're likely to be classified in terms of whether they're conditions or intermediate terms. Okay, and we'll have a look at these and just have a bit of discussion on each of these descriptive statements. So what I'm going to do is pull up 3 different descriptive statements, and I just want you to have a think about whether you think these will amount to conditions or intermediate terms in the voyage charter. Okay, we're not going to do a poll on these, and you may recall that some of these were also dealt with on the Time Charter course, but just give a second's thought to whether or not you think these will be conditions or innominate terms or intermediate terms. So first of all, the name of the vessel. Okay, so where the vessel is named in a voyage charter, do you think this amounts to a condition of the charter party, or is it an intermediate term? Okay, well, hopefully you form the conclusion that in relation to the name of a vessel, this will be a condition. Okay, if the charter party sets out the name of a vessel, then the charterer is entitled to expect that vessel will be delivered. And if that vessel is not delivered, the charterer will have a claim for damages, and it will be entitled to reject the vessel and terminate the charter party. Now that's subject to clauses relating to nomination or substitution appearing in the charter party. Okay, and what you will regularly see in voyage charters is that the owners will have a right to nominate the vessel after the charter party has been fixed. Okay, and in those circumstances, the owners will nominate the vessel at the relevant time. Once they've made the nomination, the name of the vessel is then written into the charter party and becomes a condition of the charter at that stage. Equally, the owners may have a right of substitution. Note the distinction between an obligation to nominate and a right to substitute. The owners may have a right to substitute the vessel, in which case they can in those circumstances swap one vessel out and one vessel in, provided the substituted vessel matches the original vessel in terms of its main characteristics and performance. And the next descriptive statement is the carrying capacity of the vessel. Okay, so where you see clauses in voyage charters that set out the vessel's carrying capacity, are these conditions or are these intermediate terms? Okay, well, in relation to carrying capacity, clauses will invariably be intermediate terms. That is to say that if the stated carrying capacity or if the actual carrying capacity of the vessel turns out to be slightly less than stated, then that's unlikely to give rise to a right to terminate the charter. If the charterers suffer a loss as a result, they may have a damages claim against the owner, but not a right to terminate. On the other hand, if the carrying capacity is stated incorrectly to a greater degree, then eventually there may come a time when the charterers are entitled to terminate the charter and claim damages, because the gravity of the breach is such as to justify that course of action. For example, if it means that the charterers can't load the particular cargo or a substantial quantity of the cargo, that may in those circumstances give rise to a right to terminate, but it's all a question of degree. And then how about the class of the vessel? Okay, well, statements as to class in charter parties will also be intermediate terms. This is perhaps the most surprising of the classification of the descriptive statements, because you might expect class to routinely go to the root of the contract and be a condition of the charter, but not so. And this has been clarified most recently in a case called the Arctic in 2019. And that was actually a case on a bareboat charter, so quite a different scenario to the voyage charter. But nevertheless, the principle was set out by the High Court in that case that unless a class clause is stated to be a condition of the charter, it will usually be an intermediate term, and it will be necessary for the court or the tribunal to look at the nature and the effect of the breach in order to determine the remedy that should be available for the innocent party. Okay, and this reflects a modern approach from the courts and tribunals in London of not being too restrictive in their classification of terms and really looking to the commercial and legal reality of the breach in order to determine the remedy that should be available. And finally, just on this point, in general terms, more often than not, a clause or a descriptive statement in a voyage charter, as we've seen, will amount to an intermediate term as opposed to a condition. Conditions are fairly few and far between. Well, now I am going to ask you to take part in a poll, if you don't mind. And what I would like you to say, or the question that I would like you to answer is, now that we've seen the descriptive statements, or the types of descriptive statements that appear in voyage charters, the question I'd like to put to you is, at what time in the sequence of events is the vessel obliged to comply with these statements? Does it need to comply at the time the charter party is entered into? Is it at the time of delivery? Or does indeed the vessel need to comply with these statements throughout the entire voyage and the life of the charter party? So what do you think? Okay, and hopefully the vote, yeah, there we go. And so the poll comes up now, and if you could just vote what you think. Is it at the time the charter is entered into, at the time of delivery, or throughout the whole voyage? Well, interesting. So 18% of you said at the time the charter is entered into, 31% said it's at the time of delivery, and 51% said those statements must apply throughout the whole voyage. Actually, the answer is that, generally speaking, the time the vessel must meet those descriptions is at the time that the charter party is entered into. Unless a charter party expressly applies for the particular statement to apply throughout the entire course of the charter. So, for example, in clause 1 of the as per tank void form, what this says is that the vessel's class, the vessel must be classed, and it must be so maintained during the currency of this charter. And in that example, of course, the vessel must comply with the statement throughout the whole period of the voyage. Generally speaking, if the vessel doesn't provide otherwise, it's only at the time that the charter party is entered into. So in fact, as a note for charterers really there to think about that quite carefully and to make sure that the charter party provides adequately in relation to these key characteristics throughout the whole period of the charter. Now, of course, there are other clauses that will apply, at the same time, that may well offer charterers a different recourse in the event that the vessel becomes unsuitable for the voyage. For example, the vessel needs to be unseaworthy at the commencement of the voyage, and if she breaks down whilst at sea, that may be a breach of the unseaworthiness provision, etc. So there are other potential remedies for charterers there, but generally, statements as to the vessel will apply at the time the charter is entered into only. Oops. Maybe we skipped through a couple of slides there. Bear with me for a second. I think that was all that I had to say, and it's over to Pamela now, but let me just double check I haven't forgotten anything.
No, indeed, it's me taking over now, Tom. Thank you.
Great.
Now, it's obviously of some importance to a voyage charter or a shipper of goods to know as precisely as possible when the vessel is going to arrive at a loading port in order for it to plan when it must have a cargo ready to load. A ship owner, on the other hand, will want to allow himself as much flexibility as he can in providing a date when the vessel will be ready to load. So what a ship owner wants to avoid is being tied to any contractual promise that the ship will be ready to load on the specified date, and thereby leaving himself open to a claim for damages in the event that the vessel fails to be ready by that date. Instead, a series of different provisions has arisen that seek to balance those competing needs and interests of a charterer and an owner. And commonly, these will be one of the following that you'll see on the slide there. It may be a statement of where the vessel is at the date the charter is entered into, a date on which the vessel is expected ready to load. There may be a provision that the vessel shall proceed to the loading port, which is named, and sometimes there will be a requirement in addition that this is done with all possible speed or words to that effect, such as utmost dispatch. There may be a provision also requiring the master to serve notices with expected times of arrival at the load port. And quite commonly, you'll also see a cancelling clause, which entitles the charterer to cancel the contract if the vessel is not ready to load by a given date. Now, it's important to bear in mind that a cancelling clause does not confer any right to damages, and we'll discuss this in a moment. just go back one slide a minute there. So proceeding to the load port. Now, in many cases, a voyage charter will note the position of the vessel on the date that she is fixed for her next or subsequent engagement. And many charter parties also contain a form of undertaking where owners specify a date at which the approach voyage to the load port will be completed, but they restrict this to an expectation. So the date is on or about the time that the vessel is expected ready to load. And you'll see, for example, some standard forms do this already. The GenCom form 1994 is one of those, and it has boxes on the front where you can add the details. For example, box 8 will allow owners to insert the present position of the ship, and box 9 can be used to insert a date for expected ready to load. You'll see that they also refer to clause 1 in brackets of the form, and clause 1 of that charter goes on to provide, and I'm paraphrasing slightly here, that it's agreed that the vessel now in position as stated in box 8 and expected ready to load under this charter party about the date indicated in box 9 to reinforce those provisions. You might see there that in box 9, the date is given as about, or it's abbreviated to ABT. So about simply means that there's something of a margin or tolerance in the date specified, but that margin will be a question of fact depending on all the circumstances of the case. Case law does, however, suggest that it's unlikely to be large and unlikely to be anything more than about 3 or 4 days. So what is the effect of providing for these dates? Now, as an expectation, they are not guarantees. However, the ship owner must in fact have an honest and reasonable belief that the vessel will be able to meet the expected ready to load date in the absence of any unforeseen circumstances. So an owner may well be in breach of contract if at the time he makes such a statement that the ship is actually located in such a place that it's not reasonably possible for her to actually meet that expectation. The further effect of providing this date is that the owner must act in accordance with and consistently with any expectation. So it means that where there is provision that the ship will proceed with due dispatch to a load port, the owner is under an absolute obligation to commence the approach voyage at such a time that in the absence of any unforeseen circumstances, the ship would reasonably be expected to reach the load port or be ready to load by the date provided for. An authority for that is given by the Everer and Mertus cases. So if an approach voyage is commenced in good time, then an owner will not be liable for any delay that ensues in the prosecution of that voyage, provided he's not actually at fault for any delay. I skipped a slide there, just going back. What happens when no expected ready to load date or expected date of arrival is given? Well, the Court of Appeal in the Pacific Voyager case considered that question and looked at the obligation on an owner to commence the voyage in the absence of such a date. So in that particular case, the charter party didn't contain an expected time of arrival or readiness to load date, but it did contain a term that the ship was to perform her service with utmost dispatch and to proceed to the load port of Rotterdam in that case. So that charter party, which was concluded partway through a previous fixture, contained a cancelling clause, and it also gave details about the vessel's position at the time and various estimated times of arrival during that fixture, including the discharge of the cargo and transiting the Suez Canal. So all those particular estimated times of arrival, those ETAs, were given with a qualification of all going well and weather permitting. Now, unfortunately, during her transit of the Suez Canal, the ship struck a submerged object, causing considerable damage that required months of repair. Now, not unnaturally, charterers exercised their right to cancel the charter party and also claim damages, the allegation being that owners had breached the contract by failing to commence the approach voyage to Rotterdam. So the issue for the court to decide was whether there was an absolute obligation to commence the voyage to the load port when no dates for arrival or readiness to load had actually been given, and if so, when did that obligation become effective? So the Court of Appeal confirmed the previous judgment of the High Court in that case, that the owner was under an absolute obligation to commence the approach voyage at a time when it would be reasonable to expect the vessel could arrive by the cancelling date. And in this particular case as well, the ETAs given in the itinerary for the previous charter were usable to enable the parties to decide what would be a reasonable time. Now you'll see I've put on the bottom of the slide there a note about accepted perils, and it's worth mentioning about intermediate engagements and accepted perils at this point. Often, if there's some time before the commencement of a new charter, a ship owner may want to exploit the earning potential of his vessel and fix an intermediate voyage. However, that does not affect the obligation in respect to the charter to which is already committed, and the approach voyage must still be commenced in a timely fashion and at a time when it would be reasonable to expect the vessel could arrive by any cancelling date. So it's worth remembering that the ship owner bears the risks that any intermediate engagement will overrun. It's also worth noting that any accepted perils under the charter party which an owner might be expected to rely upon, for example, in the event of any delay, are available only once the approach voyage has commenced. And this was established in the case of Monroe Brothers and Ryan. And it was the reason why the owner, in the case of the Pacific Voyager, was unable to rely upon any exception in the charter party, even though it was not at fault in colliding with a submerged object in the Suez Canal. And this was because the exceptions do not apply to the period before the commencement of the approach voyage. Coming on to cancellation. Now, cancellation clauses are, as the name suggests, clauses which give a charter a right to cancel the contract, and they're quite frequently incorporated into voyage charters. They are sometimes expressed as a fixed date for the vessel to arrive at the load port or tender notice of readiness, such as the example I've given on the slide there, or they can operate sometimes by way of a lay-can period that's provided for in the charter party. Now, what is the effect of such a clause? It simply gives right to a right or an option to cancel the charter party, with the result that the parties will no longer be bound to one another. It's an option that the charterer has. It's also worth noting that such a right or an option will be a matter of interpretation of the clause itself. So the words used are relevant in determining the extent of that right, and it's always worth checking exactly what the wording of the charter party says. It's important to bear in mind as well that it's a contractual right that operates independently of any questions of breach of charter. Therefore, an exercise of the right to cancel by a charterer does not automatically confer any right to damages against an owner. And damages are only going to be recoverable if a charterer can successfully establish and prove a breach of some term of the charter party by owners. And it may well be that one of the obligations we've just discussed about proceeding to the load port has been breached, which would then entitle charterers to pursue a claim for damages. One or two other points to note about cancellation. Some charter parties specify that the vessel must be ready to load as a prerequisite to cancelling. Clause 10 of the Jane Conform is one of those, as is Clause 5 of the As per Tank Buoy, which is set out on the slide there. It specifically mentions it must be ready to load. So it's always necessary to look at all the terms of the charter party to see when any right arises or is triggered, and actually what the extent of that right is. You'll see, for example, in Clause 5 of the As per Tank Buoy that notice is required to be given within 24 hours after the cancellation date. Can a charterer lose the option to cancel? Well, if there's a time limit expressed in the charter, then that's going to be binding. If there is no time by which an option must be exercised that is expressly stated in the charter, it is likely that a term would be implied that any right or option must be exercised within a reasonable time of the ship being tendered for delivery, and that will be a question of fact in the circumstances. And it's also worth noting, actually, that a charterer can lose a right to cancel. It may be said to have been waived if, for example, they have taken steps that are incompatible with cancellation, such as beginning to load a cargo or nominating an alternative load port if the original load port is no longer feasible. Can there be an advance cancellation if owners know that they will be unable to deliver the ship? Now, you need to remember that cancellation is usually an option given to a charterer, and an owner therefore can't compel a charterer to exercise an option. So it may be that as a result, an owner will often be obliged to bear the expense of sending the ship to a delivery place in order to comply with its contractual obligations, in the knowledge that the charterer may well then exercise the right to cancel once it arrives there, wasting all those costs. It may be possible for an owner to mitigate this type of situation arising by negotiating an express provision into the charter, allowing owners to notify charterers of a new date when the ship may be ready, and asking whether charterers will exercise their cancellation option or alternatively agree to a new cancelling date. This is sometimes called an interpolation clause. An example of one is found in the GenCon form from 1976, which actually stipulates that should the vessel not be ready to load on or before the date indicated, charterers have the option of cancelling this contract, such option to be declared, if demanded, at least 48 hours before vessel's expected arrival at the port of loading. Is it possible for a charterer to cancel in advance of a cancelling date? Well, generally no. There's no anticipatory right to cancel a charter, and a charterer must wait to see if the vessel arrives. And the authority for that is the case of the Madeleine, with the citation that I've put on the slide there. I'm now going to hand you back over to Tom, who I think is going to deal with frustration and briefly force majeure.
Thanks very much, Pamela. And yeah, as Pamela mentioned, we're now just going to look at a slightly different topic in relation to voyage charters, namely frustration. And frustration can be quite a tricky concept to grasp because it's a concept that arises, well, in English law and in a way that's quite distinct from other jurisdictions, particularly civil law jurisdictions. And what frustration essentially is it's circumstances where a contract will terminate automatically without either party needing to take a step in the event of an extraneous event that renders performance impossible or radically different to what the parties contemplated when they entered into the contract. Okay, so it's this idea of automatic termination of the contract because something happens that changes the overall picture within which the parties are performing the contract and renders it impossible or radically different to perform. Okay, and as the title to this slide suggests, it's a doctrine or a concept that is quite difficult to establish before a court or a tribunal. Courts and tribunals are usually reluctant to find that frustration applies and will try to find a way in the contract to apportion risk for the particular event to one or the other parties before they're prepared to consider that the contract may have been frustrated. And we'll go on in a moment to have a look at some of the events that have and have not been held to be frustrating events in a frustration context. Okay, so just briefly, as mentioned, an extraneous event is an event that's usually unforeseen by the parties, and importantly, it cannot arise from either a breach of the party or from a type of event that's actually already addressed or addressed in the contract or the charter party, or where risk for that particular event is already allocated. Okay, so if the charter party says that one party or the risk of a particular event is with one party, then there's not going to be a frustration if that event occurs. It has to be an event that isn't addressed in the particular contract. And then performance has to be rendered impossible or radically different. And exactly what impossible or radically different are in the context, in the particular set of circumstances, will be very fact specific. And you'll have to look at the facts in the round to consider whether this is the case. And one of the tests that you'll often hear and that's often applied is a frustration of the commercial purpose. And what that means is essentially that the commercial purpose that both parties entered into the contract for is now looks so different or cannot be achieved to the extent that the contract basically makes no sense anymore, and the parties should be treated as being discharged from their obligations pursuant to it. In certain circumstances, the interruption of a voyage may amount to a frustrating event, but that would require, first of all, just to say again, first of all, that would require that the reason for the delay in the voyage wasn't attributable to either of the parties. And secondly, the delay would have to be sufficiently grave to justify frustration. A short period of delay is not going to justify frustration. But in determining what might be a sufficient delay, for example, the characteristics of the cargo could be relevant. If you've got a perishable cargo on board, or if the contract states that delivery needs to be made on an urgent basis and you've got a long delay, that could in certain circumstances amount to frustration of the contract. And another key thing to note is that just because performance of the contract involved one or other party incurring an extra expense beyond what was considered likely at the time they entered into the charter, that is unlikely to assist them in establishing frustration. In circumstances where that happens, unfortunately, it's down to the party in question just to lump the cost, and you've got to carry on with performance. Okay, extra expense does not usually assist parties in establishing frustration. So now what I'd like to do is just go through and have a look at a few different possible scenarios where the courts have considered whether or not frustration applies. And I'd like to give you some thought, I'd like you to give some thought to this as well, please. And we're going to run 3 more polls in relation to each of these scenarios. Now, just before we go on with the polls, it's important to say, as mentioned a moment ago, that this is all very fact specific. So all I really want you to say is in very general terms whether you think, for example, the loss of a named ship might, in more often than not, give rise to a frustration example. We could all come up with examples where frustration might or might not apply under each of these headings, but just in general terms. Okay, so for the first poll, so assume the ship has been lost through no fault of either party. In principle, could this be a frustrating event based on the principles that I've just described? So if you could all vote now, please, yes or no, frustration or no frustration. Okay, hopefully any minute now. Here we go. Excellent. So 74% have said yes, that could be a frustrating event, and you're absolutely right. So if we could just move on to the slide that deals with this. Thank you. So yes, the loss of a named vessel typically could give rise or could amount to a frustrating event, because of course if the ship is lost, then in circumstances where the contract is for a ship to carry a cargo from A to B, the performance of the contract becomes impossible, alternatively radically different, and that could indeed be a frustrating event. Now, it's important to note that this will only apply usually in relation to a named vessel. Where a voyage charter provides for an obligation for owners to nominate the vessel, the owners could still be subject to an obligation to nominate another vessel if the original vessel that they had in mind is lost. On the other hand, if the owners have a right to substitute a vessel, they may not be obliged to exercise that right to substitute. So the contract could still be frustrated, even if there's a right of substitution, but possibly not if there's an obligation to nominate. Okay, and then if we can go to the second poll, and the second poll relates to the circumstances where the cargo is either destroyed or damaged, beyond repair, seriously damaged. So in those circumstances, do you think typically it would be possible to establish frustration? Oh, I see. Oh, it looks like everyone's ahead of the game, ahead of me on that one. So 80% have said no frustration in those circumstances. Well, it's interesting because obviously I've mentioned that that often establishing frustration is very fact specific, and there you can see my picture of a pile of burning soybeans that I thought was quite a good graphic for this particular topic. So the question of whether frustration can be made out on cargo destruction will, in principle, often be a question of timing. If a cargo is destroyed before it's loaded onto a vessel, then in those circumstances, it's very unlikely that frustration will be made out because it's a charterer's obligation, absolute obligation, to provide a contractual cargo for the vessel. And if the charterer is unable to do that for any reason, then that's likely to be at the charterer's risk, and the charterer bears the cost of failing to provide the cargo. So the owners may have a claim for dead freight in those circumstances. If, on the other hand, the damage or loss of the cargo occurs during the voyage through a cause that is the risk of which is not allocated to either party pursuant to the contract, then in those circumstances, it is theoretically possible for frustration to apply. And what happened in the Savona, which was a 1900 case, so a historic case on an old ship, was that a cargo of coal was carried across the Bay of Biscay. There were very boisterous conditions at sea, so boisterous, in fact, that a perils of the sea defence applied and was available to the owners. So in those circumstances, there was no allocation of risk for the cargo damage that arose. The cargo was soaked, had to be taken off the vessel. Attempts were made to essentially salvage it, to put back on the vessel and continue with the voyage, but they failed. And in those circumstances, frustration was made out, and it was held that the cargo damage was a frustrating event. Now, obviously, those of us who are experienced in dealing with cargo claims will know that in the vast majority of cases, there's fault involved in cargo damage. So in practical terms, this may be unlikely to arise, but in theory, it could. Okay, and then the next poll, please. And this is the question of whether there can be frustration of the charter where the contemplated route becomes impossible. So this is where it turns out that the route that the owners originally intended to take becomes impossible after the charter party has been entered into. Do you think that that could amount to a frustrating event? Great. Well, 59% of you have said no and 41% have said yes. And in general terms, the majority are correct. Okay, well, just while we wait for that slide to come up, this was the question put before the court in the 1960s case called the Eugenia. And what happened in the Eugenia was that a ship was due to embark on a voyage that involved crossing the Suez Canal, traveling down the Suez Canal. And in the mid-60s, there was a war in the Suez. And as a result of this, the Suez Canal was blocked at the critical moment. So just when the vessel was due to travel through the Suez Canal, canal was blocked and the vessel couldn't travel across Africa in that way. The result of this was that the owners, in order to complete the voyage, would need to go round the Cape of Good Hope, which would have incurred more time and more cost on the part of owners. So the owners argued on that basis that the charter was frustrated because performance would have been radically different to the performance envisaged by the parties when they entered into the charter party. Owners also argued at the same time that the usual and customary route was not available, and that the charter also provided that the vessel would take the usual and customary route. But what the court held in the Eugenia was that frustration was not available to owners in those circumstances. The fact that owners would have to incur more time and expense by taking a different route was not justification for frustration. And unfortunately, the owners would just have to bear the cost of that. They also said that the usual and customary route to be taken by the ship fell to be determined at the commencement of the actual voyage and not at the time that the charter party was entered into. So it was irrelevant that traversing the Suez Canal was available at the time the charter was entered into. The fact is that the Suez Canal wasn't available at the beginning of the voyage, so the usual and customary route must be the route around the Cape of Good Hope, and that was the route that the owners were obliged to take. So tough luck owners in that scenario. And that's a good example of where the courts are, the expression of a doctrine not lightly invoked, where the courts are reluctant to find frustration if performance is possible. And what about frustration in a COVID-19 scenario? I expect that lots of those listening to this talk will have come across this potential question over the last year or two. Circumstances where performance of contracts has been delayed and made more difficult due to various circumstances arising from the COVID outbreak. Well, the question of whether COVID-19 can amount to a frustrating event the answer to the question of whether COVID can amount to a frustrating event is maybe, in certain circumstances. And again, this is a really fact-specific inquiry. So if you take, for example, the situation where a charter party names a specific load port for a cargo to be loaded, and it's become impossible for the cargo to be loaded there in the way that the parties contemplated, because, for example, the port's closed or because of government restrictions. Well, in those circumstances, it may be possible to establish frustration because performance is impossible or maybe radically different if it would have involved an unacceptable delay. On the other hand, if a charter party just provides for a cargo to be loaded, perhaps within a range of ports or without naming a specific port, and the intended port or the port intended by the parties has become unworkable due to COVID-19 restrictions, but there is an alternative that could be workable, then frustration is likely to be more difficult to establish. And this is on the principle that just because the alternative is more inconvenient and more expensive for the parties have still got to do their best to perform the contract. So that's just a brief kind of example of where COVID scenarios could give rise to frustration or could not. You need to look at the facts. And then this is my last slide, and just to touch very briefly on force majeure, which often arises in the same scenarios as frustration. And what force majeure is, as a matter of English law, is a contractual, or it's a type of clause that provides a contractual remedy to parties in circumstances where unforeseen events prevent or hinder performance. And again, we're looking at events that are not the fault of either party. So traditionally, these types of events might be strikes, or they might be things like volcanic eruptions, earthquakes, this kind of thing that the party can't have expected. And shouldn't be held to performance in those scenarios. Now, the important thing to know is that force majeure in English law is a purely contractual thing. Okay, so by contrast to some civil law jurisdictions, I think it's certainly in the position in France that force majeure will apply as a matter of law. It doesn't under English law, so you need to look at the contract. Is there a force majeure clause? What does it say? What circumstances need to be present in order for a party to have certain rights pursuant to force majeure? Okay, so you need to look carefully at the clause in the contract. And if you establish that the circumstances are indeed a relevant force majeure event and they have prevented or hindered performance, depending on the terms of the contract, then it may be that parties will be entitled to rights pursuant to that clause. And equally, just touching again on COVID-19, this could give rise to force majeure scenarios. Force majeure clauses often name pandemics and epidemics as potential force majeure scenarios. So if there is one such scenario and it prevents or hinders performance, then it's possible that COVID-19 could amount in some circumstances to a force majeure event. Okay, and I mentioned force majeure with frustration, as I say, because they're both concepts that arise from extraneous events beyond parties' control, so they often arise together. And that concludes the talk. So thank you very much for bearing with us. Apologies again for the technical issues at the beginning. We'll try and iron those out for the next talk, but there we go, that's the nature of doing these things live. And on with any questions that anyone would like to ask.
I've had one question in, Tom, which I can deal with, sent in advance, and that was if there's no clear date in a charter party for cancelling a voyage, can charterers exercise a right to cancel the charter? Well, it's worth pointing out initially that a right to cancel must be expressly set out in the charter in the first place. It is a contractual right that a charterer may be given. But assuming that there is a right to cancel, determining the extent of any right to cancel is always going to be a matter of interpretation of the clause itself and any surrounding clauses. So sometimes you may well find there's no cancelling date actually specified as such, but there may be, for example, as we've seen on the slide, there may be a laycan spread of a few days when the vessel is expected to load. So this would usually be some sort of expression of time when the parties were expecting the vessel to be presented ready to load. And so if the vessel was not ready to load by the end of the laycan, or possibly a reasonably short time thereafter, then you would certainly be able to argue that this constitutes an option for the charterer to cancel by the end of the laycan period or shortly after. But you have to look at the terms of the contract and see how you can interpret what the intention of the parties was in that particular scenario.
Okay, thanks, Pamela. And then I can see that we've had a couple of questions actually on the question of the state of readiness that the vessel has to be in at the time of delivery. So let me just read out the two questions and then I'll answer them both at the same time. So the first says, what restrictions apply regarding physical readiness of the vessel at the time of delivery? And then the second question says, is there any difference between the concept of an arrived ship between commencement of lay time and the laycan? So just to summarise briefly, what the two distinct scenarios here are, on the one hand, what's the state of readiness that the vessel needs to be in when she arrives at the load port and for delivery, a valid contractual delivery to take place? And then secondly, what state of readiness does the ship need to be in order for a valid NOR to be tendered and for lay time to commence for the purposes of calculating lay time and demurrage? So on the second scenario, the first thing to say is, as mentioned at the beginning of the talk, we're going to have two talks on lay time and demurrage, and we'll look at readiness and notices of readiness in that context in detail in those talks. So we will come back to that. In terms of distinguishing between the required state of readiness on arrival and for the purposes of tendering an NOR for lay time, now in practical terms, often the two may be more or less the same. You know, the ship needs to be generally in good condition, complying with or meeting requirements of physical readiness, etc., both when she arrives for delivery and when an NOR is tendered. But there can also be distinctions. And one good way of drawing this distinction or illustrating this distinction, for example, is that for the purposes of tendering an NOR, the vessel must be physically and legally ready in all material respects at the time that the NOR is tendered. And even if it's just a technical circumstance that means that she wasn't actually ready, the NOR may be invalid. By contrast, the vessel owner will have a little more latitude in relation to the requirements on delivery in circumstances where if there's a non-material defect that arises, then the vessel, then there can still be a valid contractual delivery. And just as an example of that, there was a case called the North Sea in 1997. And what happened there was that the vessel was actually short on bunkers at the time that she was delivered at the load port. And the charterers argued that that gave rise to a right to cancel because she wasn't actually ready for delivery purposes. Now, in that situation, it was held that actually the vessel was ready for delivery purposes because the owners could put that right during the period that the vessel was loading cargo or shortly thereafter. So that's just an illustration that the owners will have a little more latitude on delivery than they will for tendering an NOR for laytime purposes. So I hope that answers that question. Any more, Pamela? I think there's another couple of questions here. Actually, I think this question has been asked in slightly different ways twice as well. It says, if the charter names a specific port which is closed, what period of delay would normally amount to an unacceptable period to frustrate the charter? And we've also had a question says, if the construction of the port hasn't actually been completed, would you consider what would be the implications of this basically on the delivery of the vessel? So I can deal with those two questions at the same time as well, because there are two questions that arise here. First of all is whether or not delivery can actually take place in circumstances where the port hasn't actually been finished, or perhaps if the port's closed. And then the second is the frustration question and the degree of delay that's required in relation to frustration. And so first of all, to deal with delivery, I think the question of whether or not a ship can be delivered is first of all a question of looking at the terms and the requirements in the voyage charter. So if a vessel is due to be or required to be delivered in a port, then, and this is the subject of a separate talk as well, if a vessel is required to be delivered in the port, then the vessel usually needs to be within port limits in order for delivery to take place. And if it's impossible for the vessel to actually get into port limits, then it may be that contractual delivery can't take place. The same applies that if delivery is due to take place on a berth, then if the vessel can't get onto the berth, then it will obviously be very difficult for the contractual delivery to take place. That's subject to clauses that you'll see in charterers that say that vessels can tender NORs for delivery purposes or lay time purposes, whether in port or not, or whether in berth or not. Usually that deals with situations of congestion, for example, so protects owners against congestion. So if it's actually impossible for contractual delivery to take place, then my view would be that contractual delivery simply can't take place. The charterers will have a right to cancel, but in those circumstances, they may not necessarily have a right to claim damages from the owners because the owners haven't actually breached the charter party. Okay, and then moving on to the question of the degree of delay before frustration would occur. Well, I mean, the first thing, as I say, is that the charterers might just exercise their right to cancel and the parties just move on. And the result of that would probably be similar to if the parties treated the charter as frustrated. Obviously, if there's a cargo on board, so that's what might happen prior to delivery. Obviously, if there's a cargo on board and the ship is approaching the discharge port, well, that's a bit different. And as I mentioned in my talk, how long that period of delay might need to be before the contract is frustrated really is a very fact-specific inquiry. And you'd need to look at things like the length of the voyage, the contemplated length of the period of delay. And remember, it's what the parties anticipate the delay is likely to be at the time that frustration would apply, not what the the period of delay actually turns out to be at the end of that period of delay in hindsight. It's what the parties consider to be the likely period at the time they're considering frustration. The cargo on board may be relevant. If you've got a perishable cargo, it may be that a shorter period of delay is required, but it's a very factual inquiry that you'd need to consider. So that's the approach that you would have to take in those circumstances. If you've got a specific set of circumstances you'd like us to consider, by all means drop us a message afterwards and we'll be happy to give you a view on the specifics.
Yeah, there's just one more, I think one final question here, Tom, and that's whether if the vessel arrives a few hours after the laycan because of a technical failure such as an engine failure, and if there is a cancellation clause included in the charter, can the charterers exercise their rights to cancel the voyage? And the answer will generally be yes, if the vessel doesn't arrive within the cancelling period or by the cancelling date or by the end of the laycan, and there is a right to cancel, then charterers would normally be permitted to exercise that right. It's worth bearing in mind, though, that that may of itself not give rise to any right to damages for any losses that charterers may have sustained, because that will be dependent on establishing a breach of contract by the owners. And where there may be technical failures on the approach voyage, it's possible that owners may not be in breach of the contract. You would have to establish that separately.
Great. Excellent. Well, I think that's answered all the questions. If any more questions do arise, feel free to drop us a line. We're always happy to consider these things and talk them through. Thank you very much for your time. And if you wouldn't mind just completing the feedback forms that will come your way straight after this talk, we would be really grateful. Thank you all very much, and see you on the 20th for the talk on safe ports. Bye.